Oh, I'm having problems going live. All right. All right. Looks like we're streaming live. All right. This is the bond hearing for case State of Georgia versus Brianna Phillips Edwards, warrant number 2024 CW 71436, charged in conspiracy to tamper with evidence. Go ahead, Attorney Clemens. This is your motion.
Your Honor, we would, as we indicated in our motion, we are asking the court to grant a reasonable bond on Ms. Phillips Edwards. As the court is aware, we had a preliminary hearing, I guess 2 days ago, so the more serious charge was dismissed. Ms. Phillips Edwards is currently on bond because the way the police brought this case, they charged her initially with one charge, and then several weeks later, then arrested her again on additional warrants. So she's currently out, I believe, in the bond on the other one is $5,000. I'm asking this court for reasonable bond. I would ask, what I would prefer is that it just be allowed to be as part of the same bond, the same bond conditions. So this count would be an unsecured judicial release, subject to the same conditions of bond that she's already on. But if the court would, the alternative to that would be that the court set bond in the amount of $5,000 as well. She is not a risk of flight. In fact, in this particular case, when she found out that she was charged, that there were new warrants, both the party to the crime that's been dismissed and the current charge, she went straight away to the jail. I mean, she found out and she turned herself in early. I spoke to the fugitive squad, said she'll be there in a few minutes. So she definitely appeared and has not done anything to indicate that she would not be a good risk on bond. In addition, she is not a risk of flight. And although the charge is conspiracy to tamper with evidence, there's no further evidence to be tampered with. There are no witnesses who be intimidated in this particular case by Ms. Phillips Edwards. She has no prior criminal history. She has significant ties to the community. She's a lifelong Georgia resident. She attended high school, and while in high school, she also attended college to get basically an associate's degree when she graduated and went on to Valdosta State and got her bachelor's degree. She then was enrolled in the police academy, actually, and was pursuing that at the time that these charges arose. I have letters of recommendation. I can share my screen with the court, but I can tell you I have an Annette McKnight has written, and she's her great aunt, and she likewise supports the idea that Ms. Phillips Edwards should be released on bond, that she has ties to the
I'm going to object to any reference to any letters. I haven't seen any letters. And so certainly, if those persons are not going to be here to testify in their letters, I certainly think, I haven't seen them. And so I'm going to object to those at this time.
Share my screen if you'd like.
Judge, you're muted.
Objections sustained. Attorney Clemens, you should have provided those documents to Attorney Freeman prior to the hearing.
Just gotten some of them. That's fine. And I'll just say this: based on the nature of the offense that she's charged with, it is not. Its penalty is not life imprisonment. She is not a risk of flight. She's already on bond, or she was on bond before they filed new warrants, and she had not committed any offense that would violate those terms and conditions on bond. She has no history of flight. And in this particular case, as the court may recall from the preliminary hearing, the evidence was that she didn't know about the crime, the initial crime before it happened. There is some evidence that says that she attempted to help cover it up or made some misstatements to the police. But beyond that, that certainly should not be a no bond situation. In this case, that would amount to punishment at this point. And under the factors in Ayala versus the state, we have satisfied all of those conditions. Hold on one other second here. I got one other thing I want to tell you. Yes. Oh, I'm sorry. I didn't indicate that she's a lifelong Georgia resident and has significant ties to the community. She has her mother. There's a total of 3 children. So she has family ties here. Her mother lives here. Her entire family lives here, except perhaps for a distant relative or something. But other than that, everyone lives here. So she has no risk of flight, nowhere to go. So we would ask the court to set if the court is not inclined to let the bond on this case, the bond on the previous false statements charge cover this, then we would ask the court for another bond of $5,000, and certainly no higher than $10,000 that she can post, with any special conditions that the court would impose. Although, as I indicated, there are no victims to intimidate and no witnesses to intimidate. I think the one witness that exists in this case outside of it is the man who participated in the destruction of the victim's body in this matter in another state. But you can certainly bar her from having any contact with that individual. He was not named during the preliminary hearing, but I certainly think the state can supply the court with that individual's full name if you'd like to put that on the bond order. So that would be that. So we'd ask for the court for a reasonable bond, if not the unsecured judicial release tied into the previous bond. That's my presentation.
All right, hold on one second, Ms. Freeman.
Mm-hmm.
All right, go ahead, Ms. Freeman.
And I'm sorry, and I do apologize for not sending Ms. Freeman the emails. I did call the office and ask for who was doing the hearing, and they didn't tell me. They wouldn't tell me. They just told me to show up in court. But that's fine.
Go ahead, Ms. Freeman.
Thank you, Judge. We're asking for Ms. Phillips Edwards to remain on no bond status. Your Honor did hear the preliminary hearing on Wednesday. And of course, the state certainly believes that Ms. Phillips Edwards was party to a crime of that murder. And I understand Your Honor did dismiss that charge. However, we will be presenting all the information to the grand jury. But regarding this case, the conspiracy to tamper with evidence, you heard the evidence. You heard that there was testimony regarding this defendant was called with her husband, Michael Edwards, about burning the shoes and gloves. There was testimony that that information was confirmed that the gloves and shoes were burned. There was testimony that Ms. Phillips Edwards also had communication with the individual in Tennessee. So we certainly think that there is a possibility for intimidation of witnesses because Ms. Phillips Edwards knows the co-defendants in this case. There are a total of 3 other co-defendants. So we believe that that is a possibility. And we are asking at this point in time, if the court is inclined to grant a bond, we certainly would ask for a condition to stay away from all of the co-defendants. There are 3 total, as well as a minimum of $50,000 on the bond. We believe that Ms. Phillips Edwards has the means to flee. And so we certainly want to make sure that that does not happen and that there is no intimidation of any of the witnesses. So we would ask for a minimum of $50,000 if the court is inclined to grant a bond. Otherwise, we're asking for no bond status.
If I could have a brief moment of rebuttal.
Certainly.
First, with respect to the statements that the state alluded to, as the court will recall, the detective did not say that Ms. Phillips Edwards actually participated in the burning of evidence. There was a phone call where the husband Mikhail Phillips had asked that that be burned. But also on that call was Mikhail Phillips' mother, and there was some back and forth. But they had no evidence that Ms. Phillips Edwards actually participated in the destruction of evidence, and the detective offered an opinion that she thought that perhaps she had told Mr. Mikhail Edwards' brother on what Mr. McHale Edwards had said, but Mr. McHale Edwards' mother was also a part of that conversation. And I specifically asked the detective if they had that evidence. So the evidence on that is slight at best. In addition to the, I think the state referenced the other co-defendants. I don't think that it doesn't really make logical sense that Ms. Phillips Edwards would attempt to tamper with the co-defendants, who are the only other witnesses, and they're in jail. So if she's out of jail and they're in jail, they'll be fine. There won't be any problem there. Secondly, even relative to the nature of the offense that she's charged with, no bond given the nature of this particular offense is punishment. I don't know when this case will even get tried, but to have her sitting in jail over this, where the evidence at best is slight, would be an injustice, and again, only be punishment. We have no problem with the special conditions of bond being to have no contact with the co-defendants, nor the one witness who I guess may end up being a co-defendant. I don't know what's going to happen. No, his case happens in Tennessee, so he's not even a co-defendant in this case properly, but to have no contact with that individual. And then as to her having the wherewithal to flee, I would point out to the court that the evidence came out. Ms. Phillips Edwards, between her and McHale Edwards, they had one car, and she was going to the police academy, and they basically shared that one vehicle. So Ms. Phillips Edwards is not a woman of means at all. So $50,000 that's not bail, that'd just be ransom at this point. I'm just suggesting to the court that a reasonable bond be set $5,000, even if $10,000, but we can compare it to the other offense for which she's already on bond. But there's nothing in her past that would suggest that she's a flight risk. It indeed only suggests that she was a responsible person who got caught up in a situation with a husband who did some horrible things, and now she's been looped into it. But that certainly does not arise to the level of no bond status. It's not even a crime of violence that she's charged with at this point. So I would ask the court to reject the no bond or the $50,000 bond and to set a reasonable bond. That's all.
All righty. Attorney Freeman, what is her criminal history?
I'm going to share the history, Judge.
No criminal history?
No. For the GCIC I have, I don't know anything. Well, certainly fits, because if she was
Going to the
police academy, right, and the only open case is related to this one, that's the false statements.
Mhm. So I do have some serious concerns with granting bond to Ms. Phillips. And that although based upon the statute and based upon the evidence that was presented, I did not find that he knew initially that he was going to go in and murder. The cover-up was serious. And I have severe concerns with her role in that cover-up. And I saw it to be substantial in assisting her husband in getting rid of the victim's body. It seems like Ms. Phillips had, at some point, a bright future, and she's just thrown it all away. She's on a different journey now, and it's not a winner in this at all. Everybody loses in an instance like this. And so initially, my thought was a strict no bond. Because of the length I feel that she went to cover up, in the same tone, she could do the same thing once she gets out, to attempt to hide any sort of additional evidence or hinder the investigation, to hinder a continued investigation into this matter. Attorney Freeman indicated 50,000. What the state is asking for with bond conditions. Because she has no criminal history, I would agree to a bond not less than $60,000 with the special conditions to stay away. She must surrender her passport if she has one. I'm going to give the special conditions that she have no contact with any of the co-defendants. Any other conditions, Attorney Freeman?
Those would be, the only ones that I have. And Judge, what I'll do,
Now, what I'd also like to impose is a curfew. And that, that she's only, it's a 7 to 7 curfew, Attorney Freeman?
yes.
A 7 to 7 curfew.
And we would also like a no contact with the witness in Tennessee. And if the court wants me to, if you want me, I didn't know if the court was going to prepare the order or if you needed me to submit the order. But I do have the co-defendants' names as well as the witness in Tennessee, because we would also want a no contact order with him.
Okay, yes, you can go ahead and compose that. With all
Okay.
those names.
Okay.
And then, and just
And I'll
one
send
minute.
it. Oh, I'm sorry, Attorney Clemmons. I also say, give me your email address. Make sure I have the correct address, and then that way, you'll be on all the communications too.
I'm gonna put it right there in the chat so I don't
Okay.
get a bunch of emails from people.
Right. Thank you.
Because that has happened before.
Right. I want to make sure I have the correct address, and so.
All right. It's in the
And where would she be residing?
I understand. Well, that's going to be a question right now, Judge, because we have to make certain that whether she is going to be able to reside at the home that she had before she was incarcerated, which is, I believe she will be. Will you be living at your current home, Ms. Phillips Edwards, or will you be living with your mother? She's on mute.
I will be living with my mother and my grandmother.
All right. I can get.
Yes, let's make sure we get that address, please.
All right. And then the last question. So 50,000. Oh, Ms. Phillips Edwards, do you
You said
have a
60,000.
passport? I'm sorry, 60,000. Do you have a passport?
No, sir.
All right. So she has no passport.
And Mr. Clemmons, if you can, do you have that address where she's going to be residing so I can put that on the order? Or do you need to get that?
I'll have to get that from her mother.
Okay, well, let me make sure you have my email address because you'll need to email that to me.
And
Please,
also, Attorney Freeman, I don't want Ms. Phillips to leave the state of Georgia without permission.
Okay. Okay.
Right. And you can put your email in the chat. That'd be great because your office guards your email jealously. I can tell you that.
You know what? I'm surprised because I get emails from people all the time.
Yeah,
And
I was surprised.
actually, I'm on the website. If you look under the district attorney's website, if you look under, I can't remember what the tab is, like anything related to bonds, magistrate court, you'll see my name and my information. But I just sent it to you in the chat.
Thank you very much. And then, well, that should be it. And then with the 7 p.m. to 7 a.m. curfew, I'm assuming if she gets employed, we will just come back to the court and
no, it's on there. You can, the curfew is there, but you're able to, I think it's, the wording is work,
Doctor appointments.
doctor's appointment, attorney. So you'll see it on there. It allows for that.
All right. Well, I'm glad you all have that in there. A lot of counties don't put that in there.
Yeah, it's already, it's on there. And so when I finish court, I'll get that prepared and send it to you for your signature. And then we'll get it to Judge Case Johnson.
All right. That is fine.
All righty. That concludes the hearing.